Jail sexual abuse lawsuit, New York City, holding officers and the City of New York accountable. Attorney Andrew M. Stengel. Sexual abuse by jail staff is a devastating violation of trust and of the law. If a corrections officer abused you inside a New York City jail, you have powerful options. A jail sexual abuse lawsuit in NYC can hold the officer, supervising officials, and the City of New York accountable. Rikers Island and the borough jails have faced documented scrutiny over staff misconduct for decades. Because of this, federal law and New York state law both give survivors clear paths to justice. An experienced New York sexual abuse lawyer can explain those paths and protect every critical deadline. This guide covers your rights, the key deadlines, and what a lawsuit can recover. Constitutional rights of people detained in New York City jails. People held in New York City jails fall into two legal categories. Due process under the 14th Amendment protects pretrial detainees, meaning anyone not yet convicted. Courts treat sexual assault by correction staff as punishment that violates due process. In contrast, the 8th Amendment protects people serving sentences after conviction. Its ban on cruel and unusual punishment covers staff sexual abuse. Both groups share one powerful remedy. An officer who sexually abuses a person in custody acts under color of state law. As a result, survivors can sue that officer under 42 U.S.C. Section 1983 for the constitutional violation. Furthermore, supervisors who knew of prior misconduct and failed to act may face Section 1983 liability themselves. Staff sexual contact with a detained person is also a crime under Article 130 of the New York State Penal Law. Consent is no defense because people in custody cannot legally consent. These protections apply at Rikers Island, the Manhattan Detention Complex, and every borough facility. Monell liability, suing the City of New York directly. Suing the individual officer is only part of the case. Under the Monell doctrine, the City of New York itself faces liability in many jail abuse lawsuits. The doctrine applies when an official policy, a widespread custom, or a failure to train or supervise cause the violation. To win, survivors must prove the policy or custom was the moving force behind the abuse. For decades, federal courts have placed New York City's jails under oversight and consent decrees. Investigators have documented inadequate supervision and unchecked misconduct year after year. That history is powerful evidence in a Monell lawsuit. Proof can include ignored complaints, prior lawsuits, and federal monitor reports. Therefore, survivors of staff sexual abuse often hold strong ground for suing the city directly. State lawsuits and the critical 90-day notice of claim deadline. In addition to federal lawsuits, survivors can pursue state tort lawsuits against the city and its staff. These include lawsuits for sexual battery, assault, and intentional infliction of emotional distress. However, every state lawsuit against New York City carries a strict procedural requirement. Survivors must file a notice of claim within 90 days of the incident. Missing that deadline can permanently bar the state lawsuit. Most importantly, the 90-day clock runs from the date of the sexual abuse. It does not start at release or when you hire an attorney. New York courts enforce the rule rigorously and rarely grant extensions. Separately, CPLR 213C gives survivors of certain sexual offenses up to 20 years to sue individual abusers. Still, acting quickly preserves every available remedy against the city itself. State lawsuits proceed in New York Supreme Court, often in the borough where the abuse occurred. The Prison Litigation Reform Act and grievance exhaustion. Federal lawsuits filed by people still in custody face another hurdle. Under the Prison Litigation Reform Act, you must exhaust every available administrative grievance before filing. Courts dismiss federal lawsuits when plaintiffs skip that step. Federal PREA standards also give people in custody protected ways to report sexual abuse. Even so, important exceptions exist. For instance, a grievance process that was unavailable in practice may excuse exhaustion. Retaliation that blocked access to the process can excuse it too. Beyond that, the PLRA applies only to people who are incarcerated when they file. Survivors who file after release do not face the exhaustion requirement at all. A lawyer experienced in these cases can analyze exhaustion and protect your federal lawsuit. What survivors can recover in a jail sexual abuse lawsuit. Damages in a jail sexual abuse lawsuit span several categories of harm. Compensatory damages cover physical injury, emotional distress, therapy costs, and pain and suffering. Medical expenses and future treatment needs count toward the recovery as well. Punitive damages can punish officers who acted with malicious intent. Additionally, federal law helps survivors afford the fight. Prevailing plaintiffs recover attorney's fees under 42 U.S.C. Section 1988. That means you can pursue justice against the City of New York without paying legal fees up front. Across New York, the toll of staff sexual abuse behind bars is real and lasting. Compensation for that harm is both legally available and morally necessary. Hold the city accountable with the law firm of Andrew M. Stengel. Strict deadlines start running the moment the abuse occurs. The law firm of Andrew M. Stengel. PC handles jail civil rights lawsuits against the City of New York and its officers. We represent survivors throughout New York and fight to recover every dollar the law allows. Contact us for a free, completely confidential consultation. Email info@stengellaw.com. For more information, please visit our website, stengellaw.com. Attorney advertising. Prior results do not guarantee a similar outcome.